On July 3, 2023, Officer Lucas Emberton of the Greenbrier Police Department in Greenbrier, Arkansas, observed a vehicle with expired tags. Officer Emberton attempted to stop the vehicle, which was driven by local mechanic Sean Bresnahan, but Mr. Bresnahan continued driving and pulled into his driveway further down the road. The interaction that followed was captured on Officer Emberton's body camera.
How you doing?
I'm good. The reason I stopped you, your tags.
Yeah, I got to get them took care of. I just got it running last night.
Okay.
It's been sitting parked for...
Hey, I'm gonna be at Walmart for a minute.
I got you. You got your driver's license with you?
I don't have it on me.
Okay. Do you have a driver's license?
I do.
Okay. What's your name?
Sean Bresnahan.
All right. You want to step back here with me? Let me get your name and stuff. What's your name, bud?
Sean. S-H-A-W-N.
How you spell your last name? Oh, you got insurance on the vehicle? Okay. I'll see if I can see it on here. Okay, bud. Hey, Sean. Can you go ahead and stay out here for me, bub? I'm on a traffic stop right now, so if you would, come on back out here, bub. Just for a minute. Okay, I'm still on a traffic stop, okay? You understand that? You want me to step in with you and grab your keys? We can either step in and give the keys, or you can come back and have a seat in the car. I don't want it to be difficult, Sean. Okay, I don't want you to enter the house without me. For your safety and for mine. That's all I'm asking. So do you mind stepping back out here with me so we can get this taken care of? Or do we want to continue to make it longer? All right, Sean, put your phone down. Okay, I'm going to detain you for a minute, okay? Try to get all this figured out. Do what?
Any particular reason why?
Yeah, you're driving on suspended.
That's why I was wanting to get in my truck. I got paperwork to show you it's not suspended.
We'll get to it. Okay?
I mean, is there a particular reason you're putting me in handcuffs?
I'm going to detain you for a minute until I get it all figured out because you're moving around, you're wanting to go in, you're wanting to get in the truck.
You asked me to sit down, I sat down. Well, actually, you asked me to come back out here. I sat back here and sat and I hadn't moved since.
Perfect. I'm going to detain you while I look through my computer.
And if you're happy to work with you, you'll be happy to work with me. Shelby, will you hush, please? Hey, Shelby, hush.
All right, let's move over here, Sean. Let's move over here.
You think the reason why?
I'm asking you to move over here.
And I understand that, and I'm asking any particular reason why.
I'm going to detain you while I do my paperwork and I figure out what's going on with your license and all that.
I'm not going anywhere.
I'm asking you again, Sean, to get up. I'm going to detain you for a minute, let you come over here where I can talk to you while I'm trying to deal with your thing.
We're talking just fine right now. I don't see the... Are you arresting me or are you detaining me?
Detaining you at this point.
Okay, well, I'm being detained. I can do so without being in handcuffs.
Okay, I'm going to put you in handcuffs and I'm going to detain you.
Is there a particular reason why I'm not being...
Yes.
I'm just trying to understand. I'm not being combative. I'm not...
No, I know you're not. I'm not. I'm asking you to comply with my orders. Yes, I'm giving you a lawful order to stand up, and I'm going to detain you for a minute until we figure out what's going on. I'm going to put them in front of you.
Okay.
Okay? While we look at the stuff. You've been over here. You've been in front of your car trying to open the hood. You're moving all over the place. I need to focus on what's going on here to decide whether you stay here or whether you go with me. If you don't allow me to do that, then we're going to stand here and talk.
I don't see why I should be handcuffed on my own property when I haven't broken the law.
You have broken the law.
What law have I broken?
Driving on suspended.
I have the paperwork to show otherwise.
Okay, well, it's not showing that in my truck.
I understand that. I have paperwork from the court that shows otherwise.
Do you have it on your person?
No, sir. It's in my truck.
Was it in the car that you were driving?
No, sir. It's in my truck.
Okay. So, no different than you being on the highway.
I know for a fact I have the paperwork. It's 25 feet away from me. I can show you that real quick and clear this all up.
We might get to that point whenever you decide to comply.
I'm not trying to not comply, but I was on my own property when you pulled up behind me, and now you're wanting to put me in handcuffs.
You were driving down the highway driving on suspended.
I have the paperwork to show my license is not suspended. It was suspended in error.
Suspended in error.
Yes, sir.
We'll get to that point, but I can't get to that point standing here arguing with you.
I mean, we could get to that point very easily. I could walk over to my truck and unlock it and give you the paperwork.
We will when I complete my investigation.
Okay.
I'm going by this paperwork, what I have to deal with.
Okay, I understand.
And then, if I can look at that, then we'll look at yours. But you haven't complied with me yet.
You asked me not to move around. I sat down. I hadn't moved since, aside from to calm the dog down, which I asked you. I've been complying this whole time, but I do not see it being necessary to be put in handcuffs.
And then I asked you I was going to detain you, and you chose not to. So now you're interfering with governmental operations.
Not interfering with any operation.
Absolutely you are. But I would have already be done. You've got two options. I'm going to detain you until I get done on my computer and trying to figure out the information, or you're going to go to jail for interfering with governmental operations. One of the two. Which one you want to do?
I'm not interfering with any government operation. I fully believe I'm not.
Okay. You can believe what you want to.
Officer Emberton threatens to arrest Mr. Bresnahan for obstructing governmental operations if he refuses to comply with a handcuff detention. Under Arkansas law, the offense of obstructing governmental operations is defined in Section 5-54-102 of the Arkansas Code, which criminalizes knowingly obstructing, impairing, or hindering a public servant in the performance of an official function. In addition to uses or threats of physical force, the statute can apply to non-compliance with a lawful order when that refusal affirmatively prevents the officer from completing a required investigative task. Whether Mr. Bresnahan's refusal to be handcuffed could constitute obstruction, therefore, depends upon whether Officer Emberton's decision to use handcuffs was itself a lawful component of the traffic stop. The 8th Circuit Court of Appeals, which has jurisdiction over Arkansas, held in the 2012 case of United States v. Robinson that officers may use handcuffs during a detention when doing so is reasonably necessary to protect their safety or maintain control of the encounter. Here, Officer Emberton asserted that Mr. Bresnahan's movement outside the vehicle forced him to repeatedly divert his attention from the information that he was reviewing on the in-car computer, and given the broad latitude that courts afford officers to maintain control and situational awareness during traffic stops, it is at least conceivable that a court could find temporary handcuffing justified. It is also important to note that, contrary to Mr. Bresnahan's assertions, handcuffing does not automatically convert a detention into an arrest, and when supported by a legitimate safety or control rationale, it remains within the scope of an investigative stop. Thus, if the handcuffing was lawful under the Fourth Amendment, Mr. Bresnahan's refusal to submit could potentially be viewed as obstruction under Arkansas law. Before we continue the encounter, I want to give a big thanks to the sponsor of this episode, Fume. If you're anything like me, you've probably had a habit in your life that didn't serve you, but you kept reaching for it anyway, not because you needed the substance, but because the ritual itself was the hook. Stress, boredom, or just muscle memory can make any habit feel automatic. And that's exactly where Fume comes in. Fume is an award-winning flavored air device that draws flavor to your mouth, not your lungs, which makes it a great way to satisfy your oral fixation with non-toxic flavors, free from nicotine or vapor, and it's safe to use anywhere, whether you're looking to keep your hands busy or curb an urge. Fume's premium wooden design is built for both flavor and function. The magnetic fidget features add an extra layer of satisfaction, making it perfect for relieving stress or staying focused. If vapor was compared to sticky soda, Fume cores are closer to herbal teas. My personal go-to flavor is crisp mint. It's refreshing, clean, and it gives you that sharp little kick that keeps your mind alert. But they have a ton of other flavors like spearmint ice, orange vanilla, cinnamon hearts, and mango. Fume has already helped over 700,000 people build better habits. Try Fume today, and if you order the Journey Pack now using my code AUDIT, you'll get a free Fume topper, an awesome accessory to level up your experience. Go to tryfume.com/audit or scan the QR code on screen. Thanks again to Fume for sponsoring today's episode.
You want to be detained for a minute? Let us get it straightened up, or you want to go to jail?
I want to be on my way, or actually not on my way. I want to be about my business.
Well, you're sure not acting like it.
It's exactly what I'm acting like. I apologize if it seems otherwise. I'll be happy to walk over to your truck with you and answer any questions you have.
Okay, and I'm going to detain you in handcuffs. All right, can you please step over here to the passenger side of my...
Yes,
Set your phone down.
I might need it for a question you have or something.
Set your phone down. Can you just go to the passenger side window and I'll roll it down? Let me look at your stuff right quick. The only reason you can't come to my driver's side is because I can't let you look at this stuff, but it's showing me that you're driving on suspended.
Why can't I look at this stuff?
Okay. Because this is just for law enforcement only.
If you see information on me, I should have access to it.
I ain't arguing with you about stupid
I'm
crap.
just making conversation.
It's ACIC. It's law enforcement only. Are you law enforcement?
I apologize.
Okay, it's not for you to see.
I apologize.
I was just explaining why I let you come over there and not over here.
And I was just seeking more clarification. I apologize.
I fully trust you to stand right here, but the only reason I can't is because of this. What's your license suspended for?
I was suspended in error for missing court in Mountain Home. My lawyer didn't inform me of the court date. Went up there, got that cleared up, and got all the charges dismissed.
When was that?
Oh, it's been a few days ago, a week ago, maybe 2 weeks. I just got back from there not long ago. Came back for my daughter's birthday.
Okay, everything that I'm looking at is showing you're suspended still. Well, right now we're gonna have to wait a minute because you're showing you got a warrant out of Clinton PD. Showing felt up here, but I will double check. Okay, let's see. Do you mind to let him get his keys? He's wanting to go in the house, but...
Oh, I just need to get my phone. I've got the code to unlock my truck on it.
Okay. Well, you didn't tell me that when you was arguing about going in the house.
Well, I just need to get my keys at first, but I didn't know it was this
Okay.
serious of a deal. I apologize.
Okay. If you'll get your phone, let you open it up. We'll check that out while I check this other out. Hey, can you run this guy for me?
Thinking lately.
I'm showing he's got a warrant out of Clinton.
He does have both sets of numbers. Clinton PD, Thatcher Pro Bond, $690.
Okay. Is he showing suspended?
Yes, NCL is suspended. Are you going to have charges?
Well, right now I've just got traffic. I mean, I don't...
Okay.
He's telling me that his license was suspended by mistake at Mountain Home, but he's been charged all the way up to this last month for driving on suspended. This year he's been cited February, May, and June 21st for driving on suspended. But I don't know what it's suspended for.
Right. Besides FTA.
Right. What you got, Bo?
So the top page is showing the license reinstatement, and then the third page shows where the failure to appear was dismissed.
Do you need to go inside, ma'am?
No.
Okay, you got your driver's license with you? You got your driver's license with you?
What?
You want to include yourself in my investigation, so I need your ID you. I need your driver's license.
Herself in her investigation, she lives here.
She just said she didn't want to go inside, so she's involving herself here. Okay, I'm not arguing. Need your driver's license.
This is my house.
I understand.
And I wasn't doing anything. You didn't pull me over.
Ma'am, this is my traffic stop. You want to involve yourself with the person that I'm talking to. And I asked you if you need to go in the house, and you said no, you're going to stay outside. So you're involving yourself in my investigation, so I need to identify who you
I'm not
are.
involving myself in your investigation.
Okay, then have your way inside.
You can't tell me I have to go inside.
Then ID yourself. One of the two. One of the two.
This is my house and my property. I can stand on my property.
You're correct.
Without you harassing me.
I'm not harassing you. You're
But you
involving
are.
in my traffic stop.
Because I
Did you not talk to him? Did you talk to this gentleman right here?
Yes, he asked me for a cigarette.
Okay, then. You're involving yourself.
That's my husband. This is my property.
Okay. All you got to do is identify yourself.
But I don't have to. You can't force me to do anything on my property.
Okay, ma'am.
You did not pull me
I'm
over.
sorry. I'm sorry. You know my job better than me. So you tell me what I need to do.
Over here in front of the school, 25.
I'll step off of my property.
I'm not asking you to go anywhere.
Jerry.
Go get Jerry, whoever Jerry is. Then he will be identified as well. If you're going to include yourself in my traffic stop.
I didn't include myself in your...
Are you talking to the person I've got in handcuffs? Then you included yourself. I do not know who he is. I do not know your relationship. Do you want to include yourself or do you not?
Officer Woody does know.
That's fine. He did not make the traffic stop. I did. Okay?
Okay, but
Would you
can't
like to
harass
go-
me on my property.
What am I harassing you about?
Trying to say I have to give you my driver's license. You did not pull me over. I'm not in trouble for anything, so I do not have to give you my license.
You are correct. You're not in trouble for anything just yet. But if you keep interfering with my investigation, you're going to go to jail.
I didn't interfere with anything.
Okay, then identify yourself or go in the house. One of the two. I'm not playing y'all's bull game, Sean. There's nobody harassing her. I asked her if she could go in the house. Okay, I'm dealing with you. I do not know who she is. That's why I want to identify her. If she wants to stay out here and talk to you. There's nothing harassing about that.
Ordering her around when you don't have the authority to order her around at this point because she's not being detained. She's not got anything to do with this.
I can ask her not to be involved in my traffic stop. If she wants to involve herself, then she has to ID herself. Okay? If she wants to go in the house, she's free to go in the house. Very simple.
Mr. Bresnahan's wife, Lacey Bresnahan, arrives at their home, and Officer Emberton threatens to arrest her if she does not go inside or identify herself. And as we have discussed many times before here on ATA, the Supreme Court held in the 1979 case of Brown versus Texas that officers cannot detain individuals and require them to identify themselves absent reasonable suspicion to believe that they are engaged in criminal conduct. And while Officer Emberton claimed that Ms. Bresnahan inserted herself into his traffic stop, which he argued required her to identify herself, there is no legal basis for this assertion. Arkansas courts have upheld obstruction charges against third parties at traffic stops, but only when their behavior actually interferes with police duties or poses a safety threat. Rather, the Eighth Circuit Court of Appeals has repeatedly held that mere presence, observation, or questioning of officers does not constitute obstruction. In the 2005 case of Walker versus City of Pine Bluff, the court found no arguable probable cause to arrest an onlooker who simply stood at a distance. And in the 2020 case of Chestnut versus Wallace, it held that citizens have a clearly established right to watch police interactions without interfering. And most recently, in the 2025 case of Willis versus Mills, the court reiterated that under Arkansas law, distraction alone does not amount to obstruction, and that peaceful onlooking, even if irritating, is protected. While applying these principles, a court would likely find that Ms. Bresnahan's mere presence and refusal to identify herself did not amount to obstruction, and that Officer Emberton had no lawful basis to compel her identification or threaten arrest simply because she was present at the traffic stop that it was occurring at her own home.
Hey, Sean, do y'all have a roof insurance on the Mustang?
The only thing I've got is one that's, I think, old in the car. I guess it ain't been drove in months.
811, I have that response when ready. Is valid, but are unable to pick up at this time. They will leave it active.
Temple. Okay, they're not gonna come get you on the warrant, okay, bub?
Okay.
So at least you don't have to go nowhere.
So that was out of Clinton?
Out of Clinton PD.
Okay, I'll
So
give them a call.
yeah, they're gonna leave it. They're gonna leave it active. So
I'll
make sure you call them and get it taken care of, okay?
Yeah, I'll give them a call in the morning and see what's going on with that.
Okay. 811 PD.
Go ahead.
You go ahead and contact JT for me, please.
Selling?
10-4.
Yes, sir.
For what?
Driving unsuspended, no insurance, no registration.
My car's on private property. You can't tow it.
It wasn't when I seen the violation, sir.
Well, it was when you initiated. If you came to initiate the stop, I was already stopped on private property. You have no authority to tow my car.
Talk to the judge.
No.
Officer Emberton informs Mr. Bresnahan that he will be towing the vehicle for driving with a suspended license, no insurance, and no registration. And Mr. Bresnahan argues that Officer Emberton does not have the authority to tow the vehicle from private property. Section 27-22-109 of the Arkansas Code permits an officer to impound a vehicle when the driver cannot present proof of insurance and they are driving with a suspended license or improper registration. As the Supreme Court explained in the 1976 case of South Dakota versus Opperman, the authority of police to seize and remove from the streets vehicles impeding traffic or threatening public safety and convenience is beyond challenge. Accordingly, statutes authorizing the warrantless impoundment of uninsured vehicles are generally found to be constitutional due to the public threat they pose. However, an officer's authority to search or seize a vehicle parked in its owner's driveway is limited. In the 2018 case of Collins versus Virginia, the Supreme Court held that officers may not enter the area immediately surrounding and associated with the home, which is known as the curtilage of the home, including a partially enclosed portion of a driveway abutting the home, to search a vehicle without a warrant or an applicable exception. Now, whether the portion of Mr. Bresnahan's driveway where the vehicle stopped constituted curtilage depends upon the factors that were identified by the Supreme Court in the 1987 case of United States versus Dunn, including the proximity of the area to the home, the presence or absence of enclosure, enclosure, how the space is used, and the steps taken to shield it from public view. While applying these factors, a court could potentially conclude that an open, unenclosed driveway that is visible and accessible to the public does not constitute curtilage, and that because the traffic stop originated on a public roadway and Arkansas law authorizes impoundment for the violations at issue, Officer Emberton's continuation of the stop in the driveway and his decision to tow the vehicle from that location were lawful. However, it is also possible that a court could conclude that a warrant was required for the seizure.
Hold on a second. Show me the law that says you can tow my car right now.
Okay, here. I'm not arguing with you. Here, I'm going to explain your citations to you. Unless you want to go to jail and bond on them.
I don't, but
Okay,
I don't
then.
want my car towed either. That's stealing my property.
I don't want you driving on the
I'm not going to drive it. I
highway.
have other vehicles I can drive. But I apparently have driving suspended license or something, so I'm not going to drive anyway.
Okay,
But you're not taking my property from my property.
okay.
If we were out on the street, you would have the absolute right to tow it.
I still
I've
have
been
the
through
right
this.
to tow it.
Not from private property, sir.
You're driving it on city street, which is a violation when you're driving on suspended, and I'm taking the vehicle because you have no insurance. I just sat there and watched you drive up Wilson Farm. You drove all the way around Tyler. You come right down through here on Linder. I'm taking the car. You have no insurance, no driver's license, and you won't register your vehicle. Okay?
I have no issues with registering my vehicle. I have tags, as you see. I just haven't updated them.
Okay. Apparently you don't understand what we can see because you do have a problem with driving on suspended and you do have a problem with registering your vehicle.
And I do have it all
Because you've
cleared
been
up. I showed
cited
you.
it very many times. Okay?
And I've gotten them all dismissed, as I've shown you.
Okay. I don't know if you got them dismissed or not.
The paperwork right there shows it.
Okay. I got your paperwork.
Okay, I'm sorry, right there.
I'm still showing that you like a $100 reinstatement fee.
That was taken out of my taxes, and that one says that the
Okay.
reinstatement fee's waived if you look at it.
That's fine. I can't, this is not what I go by, sir. I don't go by your paperwork that you pull out of your truck that's sitting in your yard.
That's
I
paperwork from the
apologize.
court with the seal.
Okay? I don't care what it is. That's not what I can go by today. Okay? I'm going by my system that I look at, and also our dispatcher looked at it as well to make sure I wasn't missing something. I double checked it. It's still suspended. You still owe $100 to Mountain Home. You need to get that cleared up with them. Until then, your driver's license will be suspended. You were decided about a week and a half ago for it. Did you argue with them as well?
Yes, sir, I did.
I'm
Same
glad
fashion.
I ain't the only damn one.
Well,
all I
I mean,
can tell
when
you.
I'm being accused of something that I've already taken care of, I
I can't help it. I didn't suspend your driver's license.
You're right.
Okay?
I understand that. And
all I can do is do my job. I do my job with my tools. I don't have any choice. That's what I'm provided. And you're more than welcome to bring this to court on the court date. And if they decide that it's not suspended, I'm more than happy for them to take care of it or do whatever they can do for you and help you. I don't have a problem with that. But today it tells me it's suspended.
okay, well, if it's not suspended,
Okay.
who's going to pay for my car being impounded when it's already
Nobody.
on private property?
Nobody. You
So-
will.
so
Because you
I-
have no insurance and you won't register the vehicle. Driving on suspended is not the only problem. You got 3 problems. Okay, here's your citation, and we're going to stand by and inventory the vehicle waiting on the tow truck. Okay?
Not saying anymore, right?
You're not detained.
Okay. The only reason you could search my vehicle to inventory
Inventory
is
to.
if y'all were taking possession of it. The tow company is supposedly taking possession of it, and it's on my private property.
Yeah.
I don't authorize y'all to search my vehicle.
You don't have to.
Search my property.
You don't have to.
Actually, you do have to have my consent to search.
No, I don't. I'm
Yes, sir,
towing
you
the
do.
vehicle and I have to inventory it. Okay?
Well, you're towing the
You're
vehicle
not
on
telling
my
me.
property.
You're not telling me how to do my job, Sean.
So-
Either shut up or go in the house or go to jail. Okay? You've got a couple options. You can go in the house or you can go to jail. You've been interfering with me the whole time I've been here, and I have not arrested you yet for interfering with governmental operations. But you're really close. Can you stand here and keep your mouth shut and let me do my job? Stop interfering with me. I'm asking you this last time.
I'll step over here.
I'm asking you this last time.
I apologize. I'll step over here.
Thank you.
I have a question.
Yes, ma'am.
Is your name and badge on that ticket? Because I would like it.
Absolutely. Absolutely. You need my card?
Yeah, that'd be great.
I'll swap with you. That's what I figured. You just want to be hard to deal with. Hey, we've got an interesting one, so I'm going to have to escort you to the office to look in this vehicle. He's being very cantankerous and says that I can't tow it, but... Hey, Sean, have you got the keys to the Mustang?
I have
Okay,
not
do you
got
want us to
anything
use
back
the
on
keys to
yet.
put it on there, or do you want him to just pull it up on
I
there?
don't put on there at all.
That was
Okay, I
William
understand that,
Henry
but we're past that point. It is going to be
2204
put on there.
Edward,
I'm just trying not to get it torn up, okay?
I still don't understand
no
what
need,
statute or
ma'am.
law
You're good.
says you can take my vehicle.
Okay, I'm not arguing with that right
I'm
now.
not trying to argue. I'm asking for verification. You have to.
Do you want us to give us the keys, or do you not?
I don't want to give you all my keys now.
Okay, that's fine.
PD 2811, I apologize. I have that.
You recording this too, Lacey? Awesome.
I am.
Because then we'll subpoena your phone and it'll be gone for a while. That way we can get your recording too. Make sure it matches with ours. So we can subpoena it and we'll send it off and get it done. Hey Sergeant, I've got to go finish this investigation by inventorying this vehicle. So I've got to escort him to his place. So I'm done with them if you're done with me here. Okay. Thanks, Tim. Do you have something to say? Did you have something to say to me?
I said you are the reason people fear the police. You're not a very good officer.
Done. Please get off my property.
Your thing here is done. You do not have a reason to be on my property. You can leave.
I thought you were saying something to me.
She was
Are you
just
done
talking out
talking?
loud.
I am talking out loud to this officer right here.
Okay, thank you.
Officer Emberton cited Mr. Bresnahan for driving on a suspended license, operating without insurance, and displaying expired tags, which was a second-time offense, and the vehicle was towed from the property. Court records show that Mr. Bresnahan did not comply with the legal requirements to reclaim his vehicle, and on September 12, 2023, while the traffic case was pending, it was sold at auction to an individual named Heath Crow, who owns a salvage yard in Shirley, Arkansas. That same day, Mr. Bresnahan filed a pro se civil replevin suit in Faulkner Circuit Court seeking the return of his vehicle. Then, on October 12th, Mr. Bresnahan filed a so-called order for delivery of property with the court clerk. The so-called order claims that the Arkansas Towing and Recovery Board found the sale of the vehicle to be illegal in a letter dated October 5th, 2023. But, despite the fact that the order stated quote-unquote "see attached," no such letter was attached to the filing. According to additional court filings, including an affidavit from Mr. Crow, Mr. Bresnahan went to the salvage yard on October 14th and began loading the vehicle onto a car hauler. Mr. Crow confronted Mr. Bresnahan, who claimed that he was there to quote-unquote get his car and that he had filed quote-unquote court papers to pick up the vehicle. Mr. Crow refused to hand over the vehicle without an actual court order signed by a judge, but Mr. Bresnahan continued to insist that the vehicle be released to him. He put the keys to the vehicle in his pocket and he refused to leave the property. Mr. Crow contacted the Van Buren County Sheriff's Office, and when a deputy responded, Mr. Bresnahan finally returned the keys and left. Meanwhile, on October 18th, 2023, Mr. Bresnahan was found guilty of all 3 traffic offenses and ordered to pay the associated fines. Mr. Bresnahan created a GoFundMe campaign on December 1st, 2023 to, quote, raise funds for legal representation, court fees, and related costs associated with fighting for my rights. According to a post on the campaign, Mr. Bresnahan got his vehicle back on January 13th, 2024, although the details of this transaction are unclear. Mr. Bresnahan failed to pay the fines for his traffic offenses, and he was charged with misdemeanor contempt of court on February 14th, 2024. He later failed to appear for his July 11th, 2024 trial date for the contempt charge, and he was subsequently charged with failure to appear. His replevin case was then dismissed on July 22nd, 2024, after he failed to comply with discovery obligations. On July 12th, 2024, Mr. Bresnahan was charged again with driving without insurance, driving with expired registration, and driving on a suspended license, as well as using so-called fictitious tags on his vehicle and a defective taillight. He once again failed to appear for a court date on September 12th, 2024. Mr. Bresnahan was eventually arrested on January 3rd, 2025, and on February 13th, he was found guilty of all the new traffic offenses, 2 failure to appear violations, and criminal contempt for the failure to pay the fines, and was sentenced to 20 days in jail. According to Mr. Bresnahan, Officer Emberton is no longer employed with the Greenbrier Police Department, although I was unable to independently verify this assertion. As of the date of writing this episode, Mr. Bresnahan's GoFundMe campaign remains open, and he has raised over $17,000. Mr. Bresnahan has not posted an update ever since he shared that he got his vehicle back on January 13th, 2024, and I was unable to locate any lawsuit filings in state or federal court. Overall, Officer Emberton gets a C-, because although he may have had a lawful reason to tow Mr. Bresnahan's vehicle, he utterly failed to de-escalate the encounter once the tensions were high. He demonstrated a total misunderstanding regarding the state's obstruction law, and he baselessly threatened to arrest Ms. Bresnahan on her own property. Viewed narrowly through the lens of traffic enforcement, much of what Officer Emberton did falls within the range of what Arkansas law allows. As discussed earlier in the episode, the combination of a suspended license, no insurance, and expired registration gave him ample authority to conduct the stop, investigate the status of Mr. Bresnahan's license, and even tow the vehicle under the state's impoundment statute. Continuing the stop in the driveway after observing the violations on the roadway was not by itself improper, and there is a plausible legal argument that towing the car from an open, unenclosed driveway accessible to the public is permissible when the stop originates on a public street and the statutory criteria are met. In that sense, the problem with this encounter is not that Officer Emberton initiated the stop or pursued the traffic charges, but how he handled the discretionary aspects of the interaction once it became clear that he was dealing with a frustrated homeowner on his own property. As discussed earlier, courts allow officers to use handcuffs during a detention when they can articulate a reasonable need for safety or control, and temporary handcuffing does not automatically convert a stop into an arrest. Officer Emberton repeatedly told Mr. Bresnahan that he was being detained, not arrested, and explained that he wanted him in one spot so that he could focus on his computer and paperwork rather than worrying about where Mr. Bresnahan was moving. However, instead of pairing that explanation with genuine de-escalation, Officer Emberton treated the disagreement over handcuffing as grounds to threaten an obstruction charge, framing Mr. Bresnahan's reluctance as, quote, interfering with governmental operations, rather than as a predictable reaction from someone who does not understand why they are being put in cuffs in their own yard. The way that Officer Emberton dealt with Ms. Bresnahan was even more troubling. When she arrived on the scene, the officer immediately tried to pull her into the stop, insisting that because she spoke to her husband and remained outside, she had, quote-unquote, included herself in his investigation and was therefore required to identify herself or go inside. As discussed earlier, citizens watching or briefly speaking to a detained person from their own property are not automatically subject to detention, and courts have repeatedly held that mere presence, observation, or even pointed questioning does not constitute obstruction. Ms. Bresnahan did not step between the officer and her husband, did not physically interfere with the stop, and did not threaten anyone. Threatening to arrest her for obstruction simply because she declined to produce her license on her own property has no basis in Arkansas law, and reflected an attempt to control the scene by inflating his authority rather than by managing actual safety concerns. Officer Emberton kept his voice relatively calm. He did not escalate to physical force beyond the handcuffing, and ultimately did exactly what the law allowed him to do on the traffic side of the stop. He issued citations, confirmed the warrant without hauling Mr. Bresnahan off to a different jurisdiction, and arranged for the vehicle to be towed as an uninsured, unregistered car being driven on a suspended license. He did not arrest Mrs. Bresnahan, even though he threatened to, and he did not stack additional charges when the situation clearly could have gone that way if he was intent on maximizing punishment. The encounter, therefore, sits in a very uncomfortable middle ground where the underlying enforcement decisions were largely lawful, but the way that his authority was communicated and defended showed a very weak grasp of the limits that should have guided his conduct. This interaction highlights how an officer can be technically within the bounds of traffic enforcement while still mishandling the encounter by overstating their authority, misusing obstruction as a threat, and failing to de-escalate when a simple explanation and a lighter touch would have been enough. Mr. Bresnahan gets an F for blatantly violating the law by driving an unregistered and uninsured vehicle on the roadway with a suspended license, for failing to pay any of his fines or even appear in court in order to defend himself, and for failing to meaningfully defend his case despite having received over $17,000 in donations from his GoFundMe campaign. There is no denying that Mr. Bresnahan was in clear violation of multiple basic traffic requirements. He drove a vehicle with expired tags. He had no proof of insurance, and he was operating on a license that remained suspended under state records, despite his repeated claims that the matter had been quote-unquote taken care of. As discussed earlier in the episode, Arkansas law treats driving on a suspended license, operating without insurance, and failing to register a vehicle as 3 separate offenses, and none of them can be cured on the roadside by explaining that paperwork exists somewhere else. Whatever may have happened in Mountain Home with a prior case or an FTA dismissal, the reality on the day of this stop was that he had continued to drive on a license that the system showed as suspended, with no insurance on file and no current registration. In that context, his insistence that the officer quote-unquote had no right to enforce the law on a public roadway was not grounded in any legal principle. It was simply a refusal to accept the consequences of his own decisions. Now, to his credit, Mr. Bresnahan maintained a mostly respectful and measured tone during the stop. He didn't threaten the officer, he didn't attempt to flee, and he made an effort to explain his side of the story without resorting to insults or physical resistance. The more troubling aspect of Mr. Bresnahan's conduct, though, emerged after the stop. Court records show that he was found guilty of the traffic offenses and ordered to pay fines, and yet he failed to satisfy those obligations, leading to a contempt of court charge and a failure to appear case when he didn't show up for the contempt trial. Rather than prioritizing the resolution of his existing legal problems, he returned to the road in the same vehicle under the same suspended status, and then was cited again for driving on a suspended license, no insurance, expired registration, fictitious tags, and a defective taillight. Furthermore, Mr. Bresnahan raised more than $17,000 on the premise that he needed funds for, quote, legal representation, court fees, and related costs associated with fighting for my rights. And yet the public record doesn't show any serious effort to retain counsel or fully litigate his claims. His civil replevin case was dismissed after he failed to comply with discovery obligations, and there's no indication that he used that money to systematically address his fines, reinstatement fees, or his outstanding warrants. Meanwhile, he continued to frame himself online as a victim of abusive policing, even as he accumulated new traffic charges and additional failures to appear. If nothing else, this story should serve as a warning to viewers to be careful and calculated about donating money to individuals who claim to be victims of misconduct. While I do commend Mr. Bresnahan only for maintaining a mostly calm demeanor during the stop, his continued refusal to accept responsibility for his own legal obligations and his failure to use substantial community support in order to resolve those issues make his overall conduct undeserving of anything higher than a failing grade. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments down below. Thank you for watching, everybody, and don't forget to check out Audit the Court if you're interested in learning about the legal nuance beyond the body cam.